right? So let's say example would be persistent over here. Let's say A has suit against B, ownership, ownership. So the subject matter of the suit is ownership. Since property is below 5 lakhs, the property is below 5 lakhs. So the suit can be instituted in which court? Tell me. I've taught you that civil court, junior division, right? Since suit is below 5 lakhs, so suit will be instituted in civil court, junior division. Let's say this is the map of the property, right? A, B, C. Sorry, A1, B1, C1. So the subject matter of suit is for A1, right? Now, what A will do in order to reach the justice, let's say, now A will do, A will first file a plaint, A will first file a plaint. A plaint will have all the details of his, property, that the property belongs side by, besides A and B1 and C1, that the suit is against the ownership of B1. So it is also against when there is suit of property ownership. When there is suit of ownership, the suit is also against possession. So ownership plus possession, right? So A will institute a suit against B, and he will mention all the facts from line by line. Facts will be mentioned under 1, 2, 3, 4, and so on, unless and until he has listed all the facts, right? And suit will go on. Every fact, every line in the fact, or every fact will talk about a different facts. I mean, let's say they are clubbing of 5 facts. So you will not use one line to dictate all of your 5 facts. You will use 5 different lines or 5 different subheadings to use these 5 facts, right? Do you get it? The fresh plaint will be instituted, always instituted under order 7, rule 1, right? In order 7 rule 1, there has been a listing that what particular content shall a plaint have, right? That is there in order 7 rule 1. Now when a suit is instituted, obviously, as I said that the property is below 5 lakhs, right? So what is happening here, that we are deciding a jurisdiction at this point only, right? We are deciding a jurisdiction at this point only. The matter about jurisdiction, or the section which deals about jurisdiction, is there in section 9, right? Is there in section 9. We will follow ingredients of section 9, and then only we'll proceed to, let's say there are 3 types of jurisdiction basically. Pecuniary jurisdiction, subject matter jurisdiction, and territorial jurisdiction. Now, peculiar jurisdiction will talk about monetary thing. Subject matter will talk about, let's say the court is to go in tribunals, or a court is to go in revenue court, or small cause court. So whatever it is, the subject matter will be decided on that. And say, here we have, as we have an example: A1, B1, and C1. Let's say B1 belong to different district, and A1 belongs to different district. Let's say district is Z1, Z2, right? When you are instituting a suit, it is important that you can institute a suit in either of the jurisdiction, whether it is Z1 or Z2. What you actually have to do is that while let's say the property is in Z1, and you have to file a case against B1, so you are filing a case in the court of Z2, Now, important is that once the jurisdiction is accepted, once it is accepted, you cannot evade it. Do you get it? Once the jurisdiction is accepted, you cannot evade it. So you can obviously file a suit in either of the court, but once it is accepted, you have to accept the jurisdiction of the court, right? So let's say you have file a plaint under Order 7 Rule 1. What will happen now? A plaint may be accepted, right? A plaint may be accepted or rejected. Only, there is a possibility of these two things, right? Accepted or rejected. Let's say the plaint is rejected. So the rejection has to be made under Order 1, Order 1, Rule 11, right? And under Order 1, Rule 12, region of rejection. Region of region of rejection has to be mentioned under Order 1, Rule 12. Do you get it? Let's say the suit is accepted, right? However, suit can only be rejected when there is chances that it does not disclose any fact, or it does not disclose any material fact, or no relief has been claimed, or the suit is barred by law. So only in few circumstances the court can reject the claim at the very first hand. Otherwise, it has to institute the suit. Do you get it? Now, now, when the suit has been accepted, the suit has been accepted, the court will issue service of summon, which is there in Order 5, right? You can also read the same in Section 27, service of summon. So, court will issue a summon to defendant which are residing at the place. Let's say B. So you have filed the suit against B. Right? This is the process that we have discussed. Now, court will summon B to appear before the court. Not only appear before the court from the date of service of summon, right? From the date of service of summon, B has to file a written statement itself. B has to now the case has we have proceeded with the case. Now B has to file a written statement itself, which is called WS, right? Under Order 8, Rule 1. Under Order 8, Rule 1, B has to file a written statement. So, what will be the rate of filing written statement? That would be 30 days from the date of service of summon. Now, let's say the B have failed in filing a filing a written statement under first 30 days. The time will be extended to 90 days. Let's say again for any particular region which to be recorded in writing, if B has failed in filing a summon in these 90 days, another at no additional 120 days from the date of service of summon will be granted. And once B has failed in instituting WS written statement against A from 120 days of service of summon, the court will declare that suit as ex parte. So the provision of ex parte is there in Order 8, Rule 10. Always remember this: Order 8, Rule 10, ex parte, right? Now there is also a provision to set aside the order of ex parte, which is there in Order 9, Rule 10. You are noting it down, right? Isn't kindly wrote it down, otherwise obviously you'll forget, and that will be lost upon yourself. Also, since we are recording this video yes, we are recording this video. So this video will be available in your app. You can anyway go through this lecture again and again. But since we are discussing line of operations, so this is very important. This is very important for you to understand CPC, because once we complete res judicata, we'll proceed to a different sections, and that then it becomes important for you to at least have a summary of what actually or how actually the proceeding in civil code goes through. Otherwise, it will be very difficult upon you to understand. So that is why kindly have this barrack with you and have a a copy with you where you can make a note, right? So under order 8 rule 1, which uh, which is under either 30 days or 90 days, 120 days, if if the WS has not served in 20 days, obviously the suit will be declared ex parte, and the court will proceed thereafter. So let's say the suit is declared ex parte or not, doesn't matter. The court will proceed with the case, right? Next in the line we have next in the line we have interlocutory proceedings, which is there in different sections. Interlocutory proceedings. Now we'll read about in different sections. Arrest, am I audible? Am I audible?
Yes, sir.
Yes, thank
Yes,
you.
sir.
There was some,
Yes, sir.
yeah, thank you. There was some problem in the network. I'm waiting for my screen to, yeah, that's there. So arrest and warrant. There is provision. People say that there is no provision of arrest in CPC. No, that's wrong. There is provision of arrest. You may read Order 38. In Order 38, there is provision of arrest in CPC as well, right? Another thing which we can do is that you can ask for temporary injunction. Temporary injunction, what does it means basically is that, let's say, B is trying to destroy the property or B is trying to sell the property. So injunction basically means that to stop B from doing anything any further. Stop B from doing anything any further on this property, right? That is called temporary injunction. However, injunction injunction generally is not a nature of permanent. So that's therein, rightly said by Urvi, that's there in Order 39. Now, the next we can do is to appoint a receiver. My pen is not working. Am I audible? Appointment appointment of receiver. So appointment of receiver, about appointment of receiver, that is there in order 40. Now next course of action that we can take is appointment of commissioner. Appointment of commissioner. So about appointment of commissioner, that's there in order 26. So what is commissioner? This is not the same commissioner that you see in see as police commissioner. Basically, what court does is that they court basically asks some advocate to be a commissioner in this particular case and visit the ground and report the actual scenario, because judge cannot go to those ground. No, let's say the property is 50 kilometers far away from the court, or let's say the property is just 200 yards away from the court of the sitting of the bench. That doesn't mean that court will start inquiring. Inquiry is not the part of court, that is the part of police. Court have the process, court have the authority to inquire through commissioner. So they will appoint some advocate to be a commissioner in the case, and obviously thereafter they can ask those advocate to state whatever that is there in the ground, to report it before the court, and court will obviously take that matter into ground, right? So appointment of commissioner is one thing that can be done. Now, we have seen introductory order that can be passed in the proceeding. However, this is not compulsory. Introductory orders are not compulsory, because that depends upon the case to case, that what case and what is the necessity of the case. It doesn't mean that after that, what is important is production of document. Production of document, right? Order 13, Rule 1. Order 13, Rule 1, production of document. Here, let's say there are some new facts, so there are some evidences, or there are some facts to be taken on the ground. And let's say if A or B, either of them have failed to enlist those facts in the very first ground, in the very first while filing of the suit. So they have an opportunity to add some documents or add some whatever is necessary in their case. They have the opportunity to add it here and not hereafter, right? So at this stage, B or A may produce the document which is in their favor. Now there will be examination of party. Examination of party under order 10, right? Examination of party doesn't mean that you have to come in the court with all the fact lawned, mucked up, and you have to just present it before the court. You are not the presenter. It's okay that that illiterate person or indigent person, or even the person who cannot speak, anyone is allowed in the court, right? Court is a temple to justice, right? So examination of party basically means that whether or not you are in agreement with the the issues that has been listed by, or the accusation that has been made by A. Let's say A says that property so and so belongs to A and it is in their ownership. Now B has to say that okay, it's their ownership, but they have they have sent they have given this property in the form of bailment. So obviously they have to provide all the requisite thereafter. So court will decide on those particular facts of bailment and not the ownership, right? Do you get it? It is not that all the issue has been in the court. It's not that all the issue is generally opposed or generally accepted. It may be that the issue will be partially accepted and partially rejected. So whatever is the acceptance, court will note it down. Whatever is the rejection, court will note it down, and court will proceed thereafter. It's not that every fact is going to be a matter of argument. right? However, every fact can be a matter of argument. These are not the two different statements, but the same. Now, what we will do, we have now we'll go through discovery and inspection.
Sir, kindly repeat the statement on fact.
What?
पूरा पहले बोला था एवरी फैक्ट फैक्ट का बारे में जो बोल रहे थे काइंडली।
Uh, I have no other. I mean, I'm not written it anywhere. What have I said? Fact.
ओके सर, ओके।
What have I said? I need to explain it again. Examination of parties. Examination of parties doesn't means basically that one is going to reject all the facts. Partially, fact may be accepted and partially it may be rejected. Right? It doesn't means actually that one has to actually reject all the plain to start the proceeding, or one has to reject one has to accept all the. However, a fact may be partially accepted and partially rejected. A fact should be, however, a fact can be rejected throughout also. All the fact can also be rejected. However, it is important that when a party or when an opposite party accept to all the fact or all the issues, all the accusation that has been raised by A, then there is no case at all. Let's say in examination, what happens that court will ask, A is saying so and so under point one. Do you agree? You say yes. A is saying so and so. In point B, do you agree? You say yes. Or court may also, to save the time of the court may also ask that, do you agree to all the facts presented by A? You say yes. There is no case. You have to say no. Court will, if you say yes, court will try and ask that क्या आप सारे के सारे फैक्ट से एग्री हो रहे हैं? अगर आप करेंगे तो केस खत्म हो जाएगा यहीं पे, आपको प्रॉपर्टी देना पड़ेगा. यू से यस, केस खत्म हो गया, आपको प्रॉपर्टी देनी पड़ेगी. I mean, court will again, because there may be a chance that person may be of unsound mind, a person may be of incapable of making judgment, or maybe a person who unable to understand the Hindi language or English language. So court will try and get into the facts that whether whatever you were saying you mean it, and if you mean it, obviously that is the end of the case. However, even if you have rejected, let's say one fact, the case will go on for that particular fact. Even if you have, I mean, that's not the only one fact that you are rejecting, or rejecting number of facts to so as to start with the litigation. So that is how it is going. Discovery of discovery and inspection. So obviously, whatever have been presented by you will be discovered by the court, right? And that is there in order 11. When we will read CPC, obviously we'll go through each one of it, and we'll try understanding what is discovery, what is inspection, how it is taking place, who is to take place, who is the commissioner, everything we'll read about it. Don't worry, right? Once the discovery and inspection has been done, the court will start with another process, that is admission. Admission. Admission in there in order 12, right? It is there in order 12. In admission, what actually we have done in examination is that is admission. Admission means that whether you are admitting to certain evidences or not, because whatever is been discovery, you need to admit that or you need to reject that. If you are, if you are going against the discovery of the fact, you obviously have to present it. So, I mean, why I am talking about all of this? Why we are talking about this chronology? Do you know why? Let's say if you ask to your client or if you ask to some advocate, you can now ask that किस स्टेज पे. Have you heard any advocate asking किस स्टेज पे सूट है? Now when you will ask your advocate or your client कि किस स्टेज पे है, I mean client won't be answer it because he doesn't know any of it. It is only upon the advocate who will answer it. अगर वो बोलता है कि एडमिशन स्टेज पे है, नाउ विल गेट एडमिशन स्टेज पे है, उसके बाद देयर विल बी फ्रेमिंग ऑफ सूट, और उससे पहले क्या हुआ है, देयर इज डिस्कवरी एंड इंस्पेक्शन ऑफ द डॉक्यूमेंट्स. नाउ डू यू गेट इट? You might have heard people discussing that किस स्टेज पे सूट है, क्या पोजीशन है. Here, when you will ask your client now कि किस स्टेज पे सूट है, you will get it. You will have a map clear in your mind, and that map will obviously help you to proceed ahead. Now, justice तो अभी नहीं मिलने वाला. It will take time, which is why we have to, yes, we are going to do this. We are going to make a long way back to justice. And here we are talking about admission. After admission, whatever has been admitted or not, you will be now frame the issue. Framing of the issue that is there in order 14, right? Framing of the issues. Here it this is also called first hearing. फर्स्ट हियरिंग. सो आज के बाद अगर आपसे कोई पूछे ना कि फर्स्ट हियरिंग केस का हुआ है क्या, विल एबल टू आंसर. फर्स्ट हियरिंग कब होता है, कब हमने सूट शुरू किया है? अ लॉन्ग वे, नो. From plaint, we talk about jurisdiction, rejection of the plaint. Then we have talked about service of summon, and then we have talked about WS, written statement under order 8, rule 1. Then we have talked about interlocutory proceedings, where we have talked about arrest and warrant under order 38. We have talked about injunction under order 39. We have talked about appointment of receiver and appointment commissioner under order 40 and under order 26, respectively. Then we have talked about production of document under order 13, rule 1. Then we have talked about examination of party under order 10. Then we have talked about discovery of and inspection of documents under order 11. Then we have talked about admission under order 12. And then there is framing of issues. And then there is framing of issues. And framing of issues is done by court, judge. It is not you, it is not client, it is not advocate who will be framing the issue. It is only the judge who will be framing the issues and not the one, not you, not me, not anyone. And here is where we say that first hearing, this framing of issue is also called first hearing. It's not there in Bare Act, right? But this is what the advocates call, this is what we call it's first hearing. Thereafter, after framing of the issues, we'll proceed with we'll proceed with summoning and attendance of witness. Attendance of witness under order 16. Summoning and attendance of witness, right? So summoning of attendance of witness, you know about that this is the stage where we call witness to be there in the court and to answer or to reject whatever is pleaded by plaintiff or the defendant, right? Here is when working of evidence act will come into picture, right? Hereafter hereafter we'll proceed with hearing of suit and examination of witness. Hearing of suit, nation of witness. Under order 18. Hearing of suit and examination of witness. Here is what you'll be calling your, whosoever is taking up the case, whosoever is, they'll be calling their witnesses to come over the box and to justify or to, refute the claim. And thereafter, we'll proceed with argument. आपने मूवीज में देखा होगा ना, the first thing, that is shown in the movie is argument only. Now is it clear before you? कि कहां से कहां आए और मूवी में क्या दिखाता है. In movie, what you see is argument only, and now then you say that ऐसा नहीं होता है. This is not how it happens in real life. So what actually happens in real life? This is what happens in real life, right? This is what happens in real life. And in movie, you start with arguments, directly argument, not framing of issue, not playing that someone, because that may be boring, no? वो तो फिर आपका मूवी बॉक्स ऑफिस पे हिट नहीं होना. अगर ये दृश्य में होता तो दृश्य wouldn't have on this much. Now here is where we'll start with examination. Under section 137 of Evidence Act, Indian Evidence Act. Right? Here is where we start with examination. Examination what? Examination in chief and re-examination. In movie, what you actually hear is argument and examination in chief or re-examination. That's the exact point that you hear, and thereafter judgment. Khatak se. It's not that easy how it goes, but as a law student, for the reason to that is very much clear that rest of the part is very procedural and it will be boring. However, you now know when you will be watching the movie now, you'll relate. Yeah, इससे पहले तो पढ़ा है जिस पे. Amrish sir have taught that, right? Now you'll be happy कि क्या हुआ है और how it is going to happen, right? You won't be in a blind face. You won't be in a blank face saying कि okay, you don't have idea about it. After examination, court will pronounce judgment. Order 20. So obviously, we'll read about what the judgment and what is the requisite of judgment. Judgment must have reason behind it. And thereafter, court will proceed for preparation of decree, right? Hereafter, actually, I mean, when you have read decree and judgment and order, you might have been confused. कौन सा पहले आता है? Order can be pronounced at the stage of what? Interlocutory proceedings. Order can be pronounced, obviously, right? Judgment is pronounced before and after that a decree is pronounced. Decree is always pronounced based on the judgment. Last few paragraph of judgments are decree only. So judgments are preparation of decree here. Preparation of decree under Order 20, Rule 6. Under Order 20, Rule 6 and 6A. Right? Hereafter, once the judgment part is done or decree is pronounced, what you can do? Either you can accept the plea, either you can accept the judgment, or you will go for an appeal, right? Or you can go for an appeal. If you are going for an appeal, obviously you have to visit the higher court under section 97 and 96. Let's say the order is passed by district court, you have to visit high court. Let's the order passed by additional district judge, you have to go for district judge and whosoever is the higher authority. Thereafter, once the appeal is passed, thereafter you will go for review and revision. Review, review under section 114 or order 46, 47 and revision under section 115. 115 it is. Right. So is it understood to you? Have you noted it down? You may take a screenshot of this. I'm giving you some time. You may take a screenshot of this, slide, and I hope that this line to justice will help you in exam, and you'll be because 90% of the question that has been asked in exam is from this chart only, which I've given you. I have given you master chart, right? Is it understood to everyone? Say yes or no. Is it understood to everyone? All right. So we'll keep today's class about line of operation only, and we'll proceed with further topic in the next class.